My mic.
Thank you for being patient.
Sure, no problem.
Thank you for...
Everybody got it?
All right. So do you want me to make a little statement and you can follow up? Okay. Yeah, sure. My name's Jennifer Bonjean. I'm with my colleagues, Attorney Ashley Cohen and Attorney Diane O'Connell. My law firm is the Bonjean Law Group, and we represent R. Kelly, Robert S. Kelly. And today we had our first day of jury selection. For any of you who were in the courtroom, you could see it's rather difficult to find people who have not received information, heard information about R. Kelly, and that really presents a challenge for us to try to get fair and impartial jurors, because it's not just a matter of people wanting to be fair and believing they can be fair. It's whether you're capable of being fair and non-biased given what you've heard and what's in your brain, and whether you can actually listen to the evidence that comes from the witness stand untainted by the lens that you may be looking through it with because you've had so much exposure to pretrial publicity, or in this case, a very, very popular documentary, Surviving R. Kelly, which I think is presenting a problem and will continue to present a problem. So that is our primary focus right now, is trying to get that fair jury. We don't have a jury yet, but we're well through the process.
Talk a little bit more about that docuseries. You asked the judge essentially to strike anybody who'd seen any part of it. He didn't agree with that, but why did you ask that?
Because there are rare circumstances in the law, Seventh Circuit acknowledges it, where we say, that the courts say, that a juror is presumed biased, no matter what he or she says. And that doesn't mean because they're lying or because they are being misleading purposely. It's just that there's too great a risk that a juror would not be able to listen to the evidence coming through into the courtroom without considering matters that they've heard outside the courtroom. If someone has seen all 6 episodes of Surviving R. Kelly, which, by the way, includes testimonials and interviews with people who are going to take the stand, as a matter of common sense, I'm sure there's been plenty of studies done on it, it would be so difficult, it would be impossible to separate out what did I hear during the documentary versus what am I hearing now? And did you actually draw some type of impression at the time you saw this person speak on TV, which, by the way, they would not have been subject to any cross-examination. They would not have had their story challenged in any way. Now they're hitting the stand. So I think it's impossible. I think this is a rare case where bias must be presumed, and that is why I asked the court to strike for cause any potential juror who had seen the documentary, any portion of the documentary. He did not agree, and as a result, it may be the case that we have no choice, that we will have jurors on our jury that have seen it, and that to me is reversible error and problematic. But we'll see. We don't have a jury yet, so we're gonna hope for the best still.
And what do you think? What is your count so far? We've been more than 50 potential jurors, but more than 30 have been excused.
So we questioned, I think, 65 today. There is now a pool of jurors who are still potential jurors. They're not the jurors. And I think we're at about 33 or something of that nature. So we're getting there. And then once we get a pool, then we'll be in the world of exercising peremptory challenges. And then it looks like we will have a jury tomorrow.
And you've been responding to this question, but the bottom line is, what do you think this is going to mean for your clients? So many people have seen that documentary and know about it.
Yeah, I mean, it's not just that there were people that came with the information about the New York case. They then announced it in a courtroom. For anybody who hadn't heard about it, now does know about it. So our position is we have a tainted jury pool. We start with a tainted jury pool to some degree. In any high-profile case, there is that potential. But there are these unique cases in history Shepard versus Maxwell is a United States Supreme Court case that goes way back. So there are these unique cases, and this is going to be one of them that we aren't going to get what the Constitution demands, which is a fair and impartial jury. But at least there is that risk that we will not get that because of the pretrial publicity that they've been exposed to. Again, and I want to make this very clear, this is not even a matter of people being bad or being untruthful or misleading. It's just people have an instinct to want to believe they can be fair no matter what they've heard. I'm a fair person, but we are human beings, and there is bias that we have, and we're not always in touch with it, and it's not something you can predict until you're in the middle of the trial when it's too late. I remember that girl. She testified or gave an interview in the Surviving R. Kelly series. I really liked her. Something along those lines. Those bells could go off, and that is the thing that we should be guarding against. But unfortunately, again, I have great respect for Judge Leinenweber. He disagreed with our position on that, but we've made our record, and that's all we can do.
You mentioned that the jury's already heard about the New York conviction.
Yeah.
This process. So is the jury already tainted?
Yes.
You can't leave that out.
No, I mean, so as a general proposition, juries aren't supposed to know about prior convictions or prior bad acts unless someone takes the stand. And of course, Mr. Kelly may still testify, but they are privy to information that they otherwise would not have been privy to. And that's negative information. The fact that he's previously been convicted in another jurisdiction is a data point that this jury members of this jury are going to have knowledge about. And how can we be assured that they will not take that into account when assessing the evidence in this case? I don't know that we can. So I think we start off in a really bad place because of that. But again, we're going to continue to fight and hope that this jury follows the law and will do their best to put that stuff aside. But it is not an enviable position, and it puts the government at a significant advantage. I hope that answers your question.
How's Robert? He seems engaged in the process.
He is engaged in the process. He said it was much better than the New York case because in New York they were actually doing physical sidebars, and he really wasn't able to participate to the degree he would have liked to. And really, jury selection is one of those things where the client should be the most active. It's a jury of his peers that he is choosing, and I feel very strongly that he should be part of that, and he is. He can hear what's going on. He's obviously being privy to our conversations. We're chatting, and we're talking about the process, and I'm glad he's able to participate. As you know, he has significant literacy issues, so it's difficult for him to quickly read a questionnaire, so a lot of it has to be orally explained to him. It slows the process down a little bit, but we're making it through.
How is his health? It's been, 3 years since I saw him here in Chicago before he was arrested. He looks like he's aged quite a bit, and he put on some weight.
Yeah, life is hard in prison and jail. The medical care is not great. He does have medical issues. I think it's a matter of public record. Certainly at sentencing, he's diabetic. He has an anxiety disorder. He was assaulted in Chicago at the MCC. So he has significant challenges. It's very stressful. His information was stolen by a BOP officer. His email, it was reported on, but a BOP officer that is not even accurate, actually accessed with her credentials and gained access to his personal information, his phone calls. So, and this is really difficult to be able to be in custody, not knowing whether any of your privacy rights are being honored. It's stressful. It's hard to, whatever your feelings are about him, he is entitled to be able to communicate with his lawyers free of fear that it's going to be recorded. fear that information will be stolen and sold or shared with YouTube bloggers. He has unique challenges in custody that other people don't, and it has not been easy, and his health is not great. Thank you. You're very welcome.
You think you're opening statements on Wednesday?
That would be my best
target
guess.
for that?
Yeah.
Okay. Very good.
Although
Thank you.
Judge Lineweather goes very fast. So.
It's a tight court. Sure, yeah.
Sir.
Don't grab the phone. That was my mistake. I did. Oh, this has to call me like... You told me like... Yeah.